now this is still a majority rule, and it's a majority rule that you need to know about. The majority of jurisdictions divide all people who enter land into three categories, and the duty that the landholder owes those people depends upon which of the three categories they fit into. People who enter my land in the majority of jurisdictions are categorized either as trespassers, licensees, or invitees, and I want to warn you, those words don't mean what they sound like they mean. And the duty that I owe those people depends upon whether they are classified as trespassers, licensees, or invitees. Now, before I go any further with this, I want to let you know that there are some very important jurisdictions, they're in a minority, but they're very important jurisdictions that have eliminated those classifications. Very important jurisdictions, minority, but an important minority of jurisdictions that say that the duty that a landholder owes to persons who enter the land is a duty of reasonable care. And what's reasonable may depend on who entered and why they entered and what right they had to enter, but in general, the duty owed is a duty of reasonable care. But in the majority of jurisdictions, it's going to depend on whether the person who entered is a trespasser, a licensee, or an invitee. Let's look at them one at a time. A trespasser, for this purpose, is someone who enters without permission. Now, we know, because we've already studied trespass to land, that there's more to it to make a person liable for trespass to land. But when we talk about the duty that a landholder owes, we simply say a trespasser is someone who entered without permission. And in general, a landholder does not owe a trespasser any duty of reasonable care. Now, I didn't say any duty. A landholder does not owe a trespasser a duty of reasonable care, but the landholder does owe the trespasser a duty to refrain from intentionally injuring the trespasser. The next category is licensee. A person who enters my land with permission is a licensee. And in most jurisdictions, to a licensee, the only duty I owe is a duty to give reasonable warning of known, dangerous, hidden, artificial conditions. Known, dangerous, hidden, artificial conditions. Known. That means they've got to be conditions I actually knew about. I'm not under any obligation to go looking for them. I have a duty to warn licensees only about conditions I knew about, and only if those conditions are dangerous. And only if the danger is hidden, because if the licensee can see the danger for him or herself, I don't have any obligation to warn him. Why should I have to warn him or her about what he or she already knows? And finally, most jurisdictions say, I don't have any obligation at all with respect to natural conditions of the land, like lakes or mountains or trees or rocks, but only with respect to artificial conditions of the land. Those are conditions that were created by humans. I may not have an obligation to warn a licensee about a hole in the ground that nature put in the ground, but I may have an obligation to warn a licensee about a well that doesn't have a cover on it, because a well is something that was created by humans. And the last category is invitee. An invitee is a very special kind of a licensee. An invitee is a person whose presence on the land confers or is likely to confer some economic benefit on the landholder. It may also confer a benefit on the invitee, but so long as the invitee's presence is likely to confer a benefit, an economic benefit, on the landholder, then that person is classified as an invitee. Another kind of invitee is a licensee who has entered the land in response to an invitation that was issued to the general public. If I'm having a party after final exams and I invite all members of the class to come to the party, all the members of the class who come to the party are licensees. They're just entering with my permission. But if I invite everyone in town to come to the party, I'm issuing an invitation to the general public, and then anyone who comes to the party is regarded as an invitee. And to a plaintiff, in most jurisdictions, it's very important to be classified as an invitee, because to an invitee, a landholder owes a duty of reasonable care. So, the duty that's owed by a landholder to a person who enters the land depends upon whether that person is a trespasser, in which case the only duty owed is a duty to refrain from intentional injuries, a licensee, in which case the only duty owed is a duty to warn about known, dangerous, hidden, artificial conditions. Sometimes, incidentally, those are referred to as traps, but that doesn't mean that I deliberately set a trap. Finally, an invitee, to whom the landholder owes a duty of reasonable care. And I want you to recognize that a social guest, a person invited to a party, is generally regarded as nothing more than a licensee. A trespasser, about whose presence I know, I've seen the trespasser on my land, may be treated by the law also as a licensee. A public official who